Not that
How come he didn't go down to community corrections?
he called multiple times.
No, I mean,
40.
okay, I'm not getting through to anybody.
No, I understand what you're saying.
Why didn't he go there?
The directive from the GPS was to call in. So he tried calling.
Okay, hold on. You're telling me, tell him to call in. He can't get through to anybody.
And they're not returning his calls.
And so when are you saying he called on mom's phone?
And that's what I'm trying to get for you. But
When did that happen? On it's gonna be one that Mr. Starr has. There's one witness, you believe?
Correct.
And then on the one that Mr. Dinowith has, there.
Correct, Your Honor.
Two. Okay, I'm gonna take a break before we begin. Which one did you prefer to go first?
I have to wait for my calls anyway, so that's your last one. I'm take it and get out of here.
Oh, for God's sakes, quit being so nice to each other. Okay, so who's going first?
Yes, I am.
Okay.
Miss Sampson is the one that.
Court recalls the case People versus Kristen Reed.
Good afternoon again, Your Honor. Raymond Cook to the people.
good afternoon again. Christina Saxon for Christian Cook. I'm sorry, Christian Reed.
Okay. What are we doing?
Okay. Your Honor, to address this bond violation. My client's phone broke. He called his mother, who is here, said he was calling a community correction from her phone. Her phone died and been trying to charge it up to go to her phone provider website to pull up the bill so I could show you proof that on what day and time that they made the attempts to call. He has shown up for every court appearance. Unfortunately, you know,
I get it, but I don't have any violations because I've not contacted community corrections.
right, he's been complying with the GPS, but they're saying he hasn't contacted since May 26th. And when he called, but unfortunately, I can't prove to you because his phone has been broken, which is why PD's office couldn't reach him. And he was calling from mom's phone. That's what I'm trying to get for you. I don't have an iPhone, so I can't charge up her phone to show that. But I personally have left messages with community corrections before, and they don't always respond right away. He's very clear now. I've given him the directive that every time he calls to do a screen print so that we constantly have proof of his outgoing calls.
Charge?
No, I said I do not have an iPhone, so I don't.
No, is it tether charge?
Yeah. Yes. Because it hasn't been going off, so it has been charged. And they're just saying he hasn't called.
No, they're saying they've been sending alerts to the device and he hasn't called.
To call, the way I read it, says sent divert alert saying call agent, not that he was in violation. It's just that his phone was broken so they couldn't reach him. So for the check-in, they use that as a method of reaching out. So it's not that
How come he didn't go down to community corrections?
he called multiple times.
No, I mean,
40.
okay, I'm not getting through to anybody.
No, I understand what you're saying.
Why didn't he go there?
The directive from the GPS was to call in. So he tried calling.
Okay, hold on. You're telling me, tell him to call in. He can't get through to anybody.
And they're not returning his calls.
And so when are you saying he called on mom's phone?
And that's what I'm trying to get for you. But
when did that happen?
The moment that it went off.
In May?
each time he
Every
said,
time. Anytime to make a noise.
But because I know you require proof, that's why I was trying to get the phone statements to show you, because the call log that her call log is only going back to Sunday. So we're having to resort to the phone bill in order to try to get the exact date and time that he called.
Phone log only goes back to Sunday?
Yeah, actually, I'm looking because there's so much activity. You have to change the setting on your phone in order to keep calls beyond 7 days, 14 days. And I've run into this many times. In my experience in IT, I know that is true, that you literally have to change the setting to hold more than
Yeah, but-
7 or 14 days.
So when's the last time he called?
I can't give you the exact date and time unless I can get to the phone bill. And we need to charge the,
Well, how long is it gonna take to get a phone bill?
Your Honor, I was just in here asking,
Online and get a phone bill.
her phone is dead, and I even came in,
Okay,
asked if
well, that's okay.
had a,
Somebody's got an iPhone charger around here.
will the prosecution,
None of this is making any sense to me.
I asked anybody, I don't have an iPhone and a charger that would fit, so I asked if anybody had an iPhone charger.
Yeah.
And she even tried calling Verizon and got into that loop with trying to get a human.
I see her on her phone right now looking through it, so I'm not sure if charging is the issue.
We've been out asking for a charger. But no, I watched the phone die, and I came in to get my charger.
Right now then.
She must have a charger now.
Sure, charge it.
Miss Reed,
Oh,
are you on a charger now that has started your phone? Thank you.
what the fuck is?
I will say, Your Honor, as you know from your experience, if he was ducking and dodging, he wouldn't show up for every court appearance. And
Oh, that's
the
it.
court would have said that he's complying.
I'm just trying to figure out, did he follow the instruction?
He said he did, but unfortunately,
He's gonna be able to get online and get me a copy of the bill. That's gonna show that.
that's what we were in the back doing. And because I know you have these other cases, unless you want to pass, give us time to get back on there. Trust that I will have it for you for end of business.
Well, he's going nowhere unless I have proof that he's called.
Okay.
So I think we're gonna do it this way. Mr. Allen, you can take him back. I'm gonna remand him back. You get me a phone bill that shows the calls, then I'll release it. If not, then I'm gonna set his bond and he's gonna sit.
Understood.
I'll pass it.
In fact, for Mr. Christian Reed on the matter ending in 0422.
So Your Honor, we are both,
I only have one file.
there is only one file. Yeah. Yeah,
I need it back up.
Pressing me.
there is, oh, that one's blank. There is two attorneys because the PD filed a motion to withdraw due to a conflict that was found just in the last couple of days. Yeah.
You write this? Okay. And I have not, I don't think I granted it because it's. Someone going to, I guess, address. Cause I have bond violations.
There is a community corrections report. I was not able to reach Mr. Reed the last couple of days. I know Miss Sack, because the conflict was approved yesterday, and Mac identified Miss Saxon to step in, but it wasn't, the PD is still the attorney of record technically. But Miss Saxon informed me that Mr. Reed changed his number since we last spoke with him. So I have not spoken with him. But it seems like she didn't know that that was pending.
I did not know. May I see?
Well, how come you haven't been contacting community correction?
My phone had broke.
Because they've been sending alerts and sirens, chief.
Yeah, and I was calling off my mom's phone.
On what?
Mom's phone.
On your phone?
My mom's phone.
You can talk to anybody?
No, nobody ever answered the phone.
Well, that can't be right.
He indicates they did leave voicemail. Your Honor, could we ask for a moment and
I think we better, because if that's what he's gonna tell me, I think we might have a problem. So I'll pass it, and can we get a copy of this? Yeah, I'll pass it. You can see it. So, no, I didn't sign the order.
Okay,
That's what you're.
are you going to?
I was gonna ask, but I'll stick around.
Is this the only case you have?
Yeah,
It is?
yeah.
So let's see. If I sign the order, then you get to go home and play with those beautiful babies, right?
Well, I got.
But see, I don't get to do that. So this is
Man,
all, as you soon understand, about me.
Other cases in front of you, Your Honor, that I have to prep for,
For when?
So that's what I will.
I'm off for a week. You got time.
Next week's about to be a busy week.
What?
Next week's gonna be a busy week.
I'm not here.
I know. Can I bring the baby? Play with her? My defense attorney is giving me advice.
Hey,
And I will say, Your Honor, just to explain a little bit, if the court wants, the reason the conflict wasn't found until now is because the conflict's name was not in the police report. It was buried in some video. So it wasn't apparent who the PDs who previously represented. The video was even based on irrelevant to Mr. Reed's case. It just so happened that I was clicking around and found it. So it
Okay.
wasn't anything that was apparent in the police report, and that's the reason I
don't want me blaming anybody from the PD's office and like going off on them because you're asking for an adjournment on the date of PE.
right.
I wasn't doing that, so I don't know why you felt the need to cover yourself.
I'm
Never mind. All right.
reading my record. Thank you.
It's likely that I will grant it. So if you have something else to do, that's fine, because I'm sure one of these other prosecutors signed to your courtroom. Anyway, all right, here we go. People of the state of Michigan versus Corey Wade Mitchell Lucas.
Alexander, on behalf of me.
Yeah.
Good afternoon, Your Honor. May it please the Honorable Court, David Burgess on behalf of Mr. Mitchell Lewis. Your Honor, I was just appointed in this matter. I'm asking for a brief adjournment of the probable cause conference.
Okay. What I'm going to do, young man, is I'm going to adjourn your probable cause conference to, will the 13th work for you, sir?
Yes, Your Honor.
All right, to August 13th. Okay, 2026, 9 a.m. I would, his bond will continue so that the parties know. Your mother, I know, right? His mother, years and years ago, back with, she didn't age. I did. Way back when I was practicing law, secretaries in my office. So tell her I said hello. My understanding is I'll send a message. I'm sure she would say, behave yourself.
Yeah.
Hear me?
Sir.
Will make me have to come after you. All right, and we'll continue.
Thank you, Your Honor.
Go out there and do something. I can say something. Court does call the case, People versus Justin Heath.
However, on behalf of Mr. Heaton, Justin, please state your name for the record.
Justin Heaton.
Hello, Mr.
Actually, before we get started, I would like to remove my lawyer from the case today.
Okay, why do you want to do that, Mr.?
We had discussed it in private in one of the holding rooms.
You did what now?
We discussed it in one of the meeting rooms.
Well, I don't think Mr. Burdell is agreeing to do that. Okay, Mr.
Sergeant.
Here's the thing, Justin. I worry when trying to do some of the things yourself. Okay, you can have a right to represent yourself, but you've got good attorneys around you. We had a in-chambers conference trying to figure out what we're going to do with the case. Let me just tell you what I decided we're going to do today. That is, we're going to adjourn it out about a week. Okay. There are some things that I want counsel to check into so that I have a full picture so that we can figure out where we go from here. Okay. Is that fair enough, Justin? I mean, I'm not, go ahead.
I understand. Does this include my initial request to be able to leave the jail and get entirely out of jail so that I can
Get yourself out, you mean?
correct and then handle the case externally from the jail's confinement?
The short answer to that is yes, but I want to make sure it can be done in a safe way. Okay, and that's part of, without going into detail on the record, that's part of the information I want counsel to get to me so that I have a full view of it and can decide how we're going to do it. That's why I want to do it. I haven't forgotten your request. I just want to do it in the right way.
Okay,
Okay. That work for you?
that does make sense. Yes.
Okay, so I'm just going to turn it out to my next available date, which is going to be August 6th. That'll give them time to do that, try to get the information to me, and then we can move on. Okay? All right, August 6th, 2026, 9 a.m. Bond will continue.
Thank you, Judge.
All right, thank you. Thank you, Mr. Heaton. Court does call the case, People versus Esudo Moreno.
Good afternoon, Your Honor. Raymond Foot for the people.
Good afternoon, Your Honor. Trovia Star, standing in for the attorney of record, Mr. Dubin. Mr. Dubin informed me that Mr. Moreno is hospitalized in the emergency room. I believe he spoke with the prosecutor, and we're asking for an adjournment.
And Your Honor, the people are also going to be asking for an adjournment today. My understanding is the victim resides out of state and was not able to secure transportation to appear today. So we were going to ask for time either to secure transportation or to file a proper Zoom request.
And Mr. Dubin told me that his client is sending him proof of inpatient to provide to the court.
Is doing what? Proof of
his hospitalization.
Okay. Given all of that, I will, if I go to the 18th, is that going to be enough time to, if you have to secure travel for the people to do
Would that
that?
be 3 weeks? If that's 3 weeks, that should be enough time.
That's 3 weeks out.
Then yes, thank you.
All right. So I'll adjourn this matter to August 18th, 2026, 9 a.m.
Thank you, Your Honor. I will inform Mr. Dubin.
All right. Thank you. Like it, yeah. Sorry. Court does call the case, People versus Robert Shelburne.
And then on behalf of people, Your Honor.
And Assistant Public Defender Ben Dunaway on behalf of Mr. Shelberg, who is joining me at the podium now.
Your name, sir?
Robert Shelberg.
Thank you.
Concept for preliminary examination. My understanding that Mr. Shelberg will be waiting on the case 25F5-5609. Or and in referring to case 24F5-5611, the controlled substance dismissed, and it's also not found in so many something.
And that is also the defense understanding. You understand and agree with that, right, Mr. Shelberg?
Yes, sir.
All right.
We're ready to go with the waiver.
So you'd be dismissing the other one ending in 611.
Right.
All right. Shelburne, you're waiving your right to have a preliminary examination.
Yes, Your Honor.
09. You understand that that's a procedure by the standard of probable cause that the offenses alleged were committed and that you committed.
Yes, Your Honor.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
Well, on that case, also waive the right.
Yes, sir.
Preliminary examination having been waived, defendants bound over to circuit court on both counts.
Stand mute, waive the formal reading.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to both charges. Pretrial will be set for
12th at 1:30 for Judge Conlon.
August 12th, 2026, 1:30 before Judge Conlon. That matter found will continue, and any other matter 5611. The information in that one. That case it's dismissed.
Thank you, Judge.
Thank you. Court does call the case People versus Christian Reed.
Good afternoon, Your Honor. Raymond Cook, people.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Reed.
Good afternoon, Your Honor.
Their fine public defenders would be able to handle it, just not Chinauza. Okay.
Fair enough. Thank you, Your Honor.
Court calls the case People versus Clifton Watson.
Alexander on behalf of people, Your Honor.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Watson, who's approaching now. Mr. Watson, will you state your name for the record?
Rickman Levi Watson Jr., Your Honor.
At this time, you were unable to proceed at count 1 in case 26F2075. We'll be asking for remand on count 2 to the report, and then in case 26F20704, people are unable to proceed as to counts 1 and 2, ask for remand on counts 3 and 4 to district court as well.
Defense will move to dismiss those counts, Judge.
Oh, I told you.
In case 7-5, the people being unable to proceed. As to count 1, court will dismiss count 1, continue to defend its plea of not guilty to count 2. I'll set that for pretrial. You need to know city or township. Well, hold on. It's or they're DV, so it doesn't matter.
Right.
Okay, go ahead.
13th at 9 a.m.
August 13th, 2026, 9 a.m. That is before Judge Barr. Bond will continue in that matter. On the other case, counts 1 and 2 were dismissed. I'll continue to defendants not guilty pleas. That's counts 3 and 4. Set a pretrial, it's the same date. August 13th, 2026, 9 a.m. before Judge Barr. Bond continued.
Your Honor, may I make a brief bond argument? My client's behalf?
Why not? Everybody else in your office has to.
Give it a try.
Go ahead.
Your Honor, based on the state unable to proceed on those counts and the remand on the misdemeanors, Mr. Watson is asking for consideration for a personal bond. He does have a pending matter out of Wayne County that he is on a personal bond for and is on tether for, and he reports that he still has the tether on his ankle, like to be able to be released from custody so that he can attend to those matters. He reports that he would reside with his mother, has no reason to have contact, complaining witness would not contact her and would follow all orders of the court moving forward.
Response.
This one, to object, he did have long relations long with so see for making calls to the victim. So at this point, I would address before Judge Donovan.
Is it the same victim? Alleged? Yeah. No. That's gonna cause a bit of a problem. I'm gonna deny the request. I've now 2 DV charges against him, so motion to modify bond is denied. Right?
Thank you.
Court calls case People versus Larzell, Washington.
Good afternoon, Your Honor. Raymond Cook for the people.
And good afternoon, Your Honor, Assistant Public Defender, Nancy Carey Akinruli, on behalf of Mr. Larzell Washington, who's approaching. Washington, go ahead, stand on this side. State your name for the record, please.
Larzell O'Neill, Washington.
Judge, we do move to dismiss.
People being unable to proceed, this case is dismissed on defendant's motion. That's without prejudice.
Thank you, Your Honor.
Thank
Okay, counsel. Excellent.
So there are many of us that got an opportunity to actually meet Zach and release better hand. He's a great guy, and normally I wouldn't put it that way. But of like the 10 of us that talked about it afterwards, great guy. We all decided that we like him better. Just saying. That's how the vote came. Court just called the case, People versus Misty Davis.
Good afternoon, Your Honor. Lori Zaki, Assistant Public Defender, with and on behalf of Ms. Davis, who's approaching. Could you state your name to the court? Ms. Davis.
Here.
Nor was state why I said the woman here or unable to see it.
And accordingly, we would move to dismiss, Your Honor, count 1, and we would ask to address bond briefly.
We'll dismiss count 1, continue the defendant's not guilty as to count 2, set pretrial in this matter for
August 17th at
August 17th, 2026, 9 a.m. before Judge Washington. As to bond.
So, Your Honor, Ms. Davis, I believe, was released in this case on a personal bond with a tether. She's being held in jail on a probation violation that she's going back to court for next week. I think she has only a little bit of time left on that case. I believe she's almost maxed out. Her concern is that—
In which case?
On her probation violation, so not this case. My request for this court is to remove the GPS tether requirement so that if and when she's released on her probation violation case, she won't have a barrier to her release. She doesn't have a phone and she doesn't have a phone number to provide community corrections. And my understanding is they'll need that in order to install the GPS tether. I know that's presented a problem for some of our clients in the past. So she understands the no contact and she actually very much wants a no contact with her wife, who's the complaining witness in this case. This
is a DV second. I'm not removing the tether. Okay.
Understood, Your Honor.
You can ask, but I'm not. I'll let you finish your argument, but that has never been this court's practice. Tether will remain.
Understood, Your Honor.
All right.
All right.
Motion for bond modification. All right. Court does call the case, People versus Gregory Huff.
Good afternoon, Your Honor.
Good afternoon.
May it please the court, Dwayne Johnson, P 41842, on behalf of Mr. Gregory Huff, who is standing to my right.
Your name, sir?
Gregory Allen Huff.
So this is Mr. Johnson, where I'll beat my staff into making me take this no contest plea. All right, go ahead. I'm just calling it like I see it.
Thank
Pardon? Oh, you browbeat him. Okay, all right.
Well,
I didn't know. All right.
We have a case in which defendant pleading to count 2 domestic violence with 93 misdemeanor under 769(4)(a). The people were dismissed.
Yes, and as I look at the plea form, that's the court's full understanding of the agreement. However, prior to the signatures, he does understand I would not be the sentencing judge in this.
yes, Your Honor.
All right, I'll check that box. All right. And counsel, that's your understanding of the agreement?
Yes.
All right. May I have him sworn?
Right hand. Do you solemnly swear in the front of the testimony you're about to give the whole truth and nothing but the true self you got?
Yes.
Station and
Gregory Allen Huff.
Sir, it is this court's understanding you're going to plead no contest to the charge of domestic violence. That is a misdemeanor punishable by up to 93 days jail, $500 fine plus court costs. You understand that?
Yes, sir.
All right. You understand what a no contest plea is?
Yes.
All right. Well, 2 things about it I have to make sure that you understand. The first thing you need to understand about it is it means that it's not that you're no longer desirous or wanting to contest this domestic violence charge. You understand that?
Yes. Yes, sir.
Well, you don't want to. It means that you're no longer wanting to fight about the domestic violence charge in this case. Put it that way. You understand that?
Yes.
Okay. Second thing you need to understand is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that?
Yes, sir.
Okay. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Washington in the 14B District Court. Understand that?
I don't know where 14B is at.
Well, that's in Ypsilanti Township.
Oh,
Same county of Washtenaw, but it's over in Ypsi Township.
okay.
And Judge Washington is the judge there. You understand that?
Yes, sir.
That's a judge that would be sentencing this case. You understand that?
Yes, sir.
All right. Basis for the no contest plea?
Civil liability, Your Honor.
So, sir, to the charge of domestic violence, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes.
Understand that?
Yes, sir.
I don't have a copy of one. Did you go through an advice of rights form, sir?
So, I'm sorry.
Did you sign an advice of rights form or go through one?
Is that what that?
I don't think we signed this.
If you haven't gone through that, then let me just stop the plea right here. I'll bring him back up, let you go through that with.
Well, Your Honor, we did go over the advice of rights. I told him what his rights were. I didn't know. We just had the plea form, so he signed that.
Oh, okay.
We did go. He knows what.
Went over those? Okay.
We went over his rights. So you just need the signature.
Yeah, because I signed one.
Mm-hmm. Just sign right there. And you need the address and everything. Is that correct, Karen?
Yes.
Okay. So fill out complete your address down.
Print it.
See.
in today's state. 728, 728. Yep. Thank you, Your Honor.
You signed that advice of rights form. Do you have any questions regarding any of those rights, sir?
No, sir, we went over that earlier.
Okay. You understand that you're giving up the rights that are contained on that form, particularly the rights under paragraph 5. You'll see a copy on the podium. Because those are your rights which are part of a trial. Right here. You understand you're giving up those specific rights.
Is that right?
Mm-hmm.
Okay. I gotta still be proven.
This space you can involve the stretch, you have to go through all of it. Yes.
Yes.
You understand, you?
You understand that, sir?
Yes, sir.
All right. You understand you're giving up your right to appeal of right.
Appeal outright.
All right. It means that if you don't like the fact that you have a conviction or the sentence in the case, you wouldn't have an automatic right to appeal that. You'd have to ask permission of the higher court, that being the circuit court, to appeal that. You understand that?
Yes, sir.
Are you on probation or parole?
No, sir.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
All right. Court has been provided Washington County Sheriff's Office report for their 26-36699. Any objection from counsel to the court reviewing that report?
No objection, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court?
You have.
Court will accept the defendant's no contest plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B. Probation sentencing will be August 1st.
Can I check this, make sure it's a good date?
Yeah, but it's only date.
That doesn't matter. I'd have to contact the court there.
Yes, you'd have to contact.
Okay, well, I'll just write it down.
August 31st, 2026, 9 a.m. That's before Judge Washington.
Okay. Your Honor, we did want to address one bond condition if we can.
Okay.
Your Honor. My client's wife is in the courtroom. And she does want him to return home. So I was wondering if the condition could be no assault of contact and allow him to return home. It is a financial hardship for them as well. And she's also dealing with some personal issues that, you know, he can assist her with. But she would like for him to come home.
One moment, Arvid.
Right.
Okay.
Record should reflect we've had a brief bench conference in this case. What I am going to do is I am going to modify the defendant's bond. I am going to add a provision of no non-consensual contact. You understand that, sir? Just so that you understand, I'm gonna let you have contact with your wife, but if for whatever reason she does not want to have contact with you, we have to leave.
Yes, yes, I understand.
That,
Yes, sir.
and then I will delete the no contact provision and delete also the no go to provision. Did you bring your SoberLink testing device with you?
Yes, sir.
Have it with you?
Yes, sir.
What I'm going to do is I'm going to change that from a SoberLink testing device. You can go right over to corrections today. And I am going to order you on to a Scram testing unit.
I can still explain to you how to.
There's what?
Explain to you
You
how to.
understand that, sir?
Sorry.
It's going to be a 24/7 monitoring of your alcohol consumption. You won't have to blow into a machine, but you'll have to download once a week. Okay?
Yes, sir.
So with those conditions, bond, its monetary form will continue.
Thank you, Your Honor.
Thank you.
Okay. So he should go over there now to.
You should go over there now. We'll contact them.
Do you know where that is?
Yes, that's right around.
Yep. Go out the building.
Okay.
Good seeing you, Ryan.
Thank you.
Thank you.
Court calls the case versus Matthew McLean.
And is that on behalf of people, Your Honor?
Ready to judge. Portia Seek, First Assistant Public Defender on behalf of Mr. Klein. When you arrive, please state your name for the record, sir.
Matthew McLean.
President Day has under preliminary examination at this time for see us to count 1 and 2 after count 3 to be remanded down to the district court.
We'd be asking for dismissal on counts 1 and 2, please, Judge.
Court will dismiss counts 1 and 2, continue to defendant's not guilty plea as to count 3. I'll set pretrial in this matter for
August 17th at 9 a.m.
August 17th, 2026, 9 a.m. before Judge Washington.
Judge, I believe you have a PR bond on Mr. McLean right now. Was released. I believe you currently have a PR bond. Was released to treatment for Mr. McLean.
I have a personal recognizance with. Is he held on something else?
No, Your Honor, it's just these 3 charges now.
That's correct, Your Honor. He was remanded back into custody for calls.
Calls, correct. Gotcha. Okay.
That's what you have, Judge. PR was.
I don't have.
Okay, I'll prepare one.
Okay, I don't have an order.
All right, that's what I was checking.
Okay. So at this point, I'll continue his bond and we'll get the order and we'll deal with it.
Thank you so much, Judge.
Thank you.
All right. Yeah, somebody's a go.
Court calls case People versus Rodney Clark.
Good afternoon, Your Honor, Raymond Cook from People.
Good afternoon, Your Honor. Assistant Public Defender, Shanazi Carey, I can really on behalf of.
Really? Slow in.
Judge, I'm going to ask if the court would be willing to recall this case. My client, can we approach, please?
Mr. Cook said no. Come on.
No.
But I see you. I saw it.
Oh, ding. Oh. Court does call the case People versus James Pittman.
Good afternoon, Your Honor, Raymond Cook from People.
Ready to Judge. Portia Feast, First Assistant Public Defender on behalf of approaching the podium. When you arrive, state your name for the record, sir. State your name.
James Arnold Pittman.
Thank you, sir. What are we doing?
First, the name is as it relates to the following 0706, the home invasion armed robbery. The people are unable to proceed on that path. I believe we were expecting a waiver on the other matter.
On 0707.
Correct.
Yes, Your Honor, I believe that in exchange for the waiver, the people are agreeing.
Not to add any additional charges. Felony waiver.
So we are waiving on that file 0707, Your Honor. And obviously no objection to dismissal of 0706.
All right, sir. On this file ending in 0707, the charge of carrying concealed weapon and the other charges, you're waiving your right to a preliminary examination?
Sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Sir.
You understand you won't have that hearing and you'll proceed to circuit court on the all 4 counts.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant on that case is bound over to circuit court on all 4 counts.
Thank you, Judge. We waive formal reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
1:30, judgment.
August 10th, 2026, 1:30 before Judge Hamud.
Thank you very much, Judge.
Thank you very much, Honor. Thank you, bond continued.
Your Honor, may I actually address bond briefly?
Yes, you may.
Hold on.
As I was looking
Say
at
something.
my- sure if the court has the same right. I'm seeing he actually has a PR bond. Bonding 07 being held up authority on the file of this.
Thank you for the heads
I
up.
will be making a motion to increase on PR bond $20,000 only requested by the people at the time of the arraignment. I'm not sure why you gave a PR on one case and $100,000 on the other one.
I don't either, but you know I did do that.
Thank you, Judge. We'd be asking for a bond as well. We'd ask for a nominal bond. He has a parole hold. He's not going.
Oh, he's got it.
Play.
Okay.
So we.
All right. So what I will do is then in case ending in 0707, I will increase the defendant's bond to a $20,000 cash surety bond in that case. All right. And in the other case, the 0706, that case is.
Thank you, Your Honor.
Thank you very much, Judge.
Thank you.
Yeah, this is amending the statement.
My number.
No, you're good.
Thank you. No problem. Thank you, Judge.
That it for transport or? One that's open. Court calls case people versus D'Anthony Buford.
Is that on behalf of Your Honor?
Good afternoon, Your Honor. Zoe Zidunzik, student attorney, requesting permission to practice pursuant in MCR 8.120.
I don't recognize you. No, go ahead. Go ahead. I'm listening. No, I just needed to communicate with my staff. Go ahead.
Oh, you're good. Zoe Zidunzik, student attorney, requesting permission to practice pursuant to MCR 8.120 under the supervision of Assistant Public Defender Laura Yagi.
Well, that's your intern?
Yes, Your Honor.
Sorry.
No,
No. Where are you from?
I'm from Detroit Mercy Law.
Sorry. Where are you originally from?
I grew up in Detroit.
Did you?
I did.
All right, 313. Go ahead. All right. And where'd you go to undergrad?
I was at Madonna University.
Wow. Religious theme notice.
What?
All right. Well, welcome aboard. Like Miss Yagi as a supervisor?
Absolutely.
Do you?
Yeah.
You have to say that, don't you?
No.
Oh, you can talk. You can tell me. All right. Permission to practice is granted.
Thank you, Your Honor. Zoe Zidunzik appearing with and on behalf of D'Anthony Buford. State your name for the record.
Yeah, thank you for your honor.
Thank you, sir. All right, what are we doing?
Your Honor, the concept of preliminary examination at this time, the court unable to proceed as to count 1 with expert and on count 2 to district court.
Your Honor, we move to dismiss count 1.
Count one is dismissed. I'll continue to defendant's not guilty plea to the count two. Pretrial will be set for August 19, 2026. Said 9 a.m.
Yes.
Judge Perry. Okay.
The sheets that I
8/19, 2026, 9 a.m. before Judge Perry. Bond will continue. Thank you. Thank you. Good meeting you. Yes, I did.
Thank you.
Do anything. Do anything though. She's really happy. Why is she like that? Why is no? She's like really.
Yeah,
She's like no, but she's like really happy about things.
I know it's weird.
Huh? She sat over there all that time. Didn't say a word. Then Yagi gave her a case. Huh? Where am I mean? Oh, is that me?
No,
I'm sorry. I'm sorry for being mean.
no, you're not. Good job.
I know you should have introduced me. This is what I'm talking about. This is all your fault.
I take full responsibility. And it.
Okay. She did a wonderful job, by the way. So she's got a, huh?
Despite being thrown in.
Despite being thrown in, and despite me as the supervisor, she did a good job. Okay, well, who's next to her? You weren't gonna introduce her either? No, fine, sit down, Yagi. I'm not talking to you anymore. You don't introduce anybody. She just travels around with all these people. All right, anyway, what are we doing?
So you're silent,
Thank you.
but I just saw Miss Saxon walk. That's the recall.
Okay. Is he here?
He's been here. That's the recall on the
Oh,
bottom.
we're calling the bond value.
And that's Miss Kiriak and please,
Where'd she go?
hopefully looking for her client.
Right, but her client isn't gonna be here till 3.
Oh,
She didn't.
I may have missed that. Then all we have left are the two that are holding.
Okay, and how many witnesses are on each?
So on Mr. Wick's, I believe there are 2. And then on Mr. Stars, I believe there are 5.
On that one, it's actually only ended up to be one with. One.
Hold on a second. So. Are we ready in yours?
Yes,
Court does call the case of people versus Lance Ford.
Good afternoon, Your Honor. Agreement to cook. Well,
Good afternoon, Your Honor. Toby is on behalf, Mr. Cook, Mr. Cook, stand in 16. Mr. Ford. Yeah, I'm sorry, Mr. Ford. I said Mr. Cook. It's been a long day. Mr. Ford. State your name. I'm sorry.
No.
Mr. Cook is right there. I'm not representing.
No, don't even. All right.
Your Honor, time set for preliminary examination. The people are ready to proceed. I do have some preliminary matters once the court's ready for those.
Okay.
Was it?
Come on.
Yeah, so that's what I was going to trust.
Oh,
So, Your Honor, before we begin, the current complaints alleges 2 counts, count 1 felonious assault, count 2 carrying a concealed weapon. I do not intend to proceed as to count 1, so we'll be proceeding just as to count 2, and I'll only be moving for bind over on that count 2 of carrying a concealed weapon. Additionally, I'm not sure if the defense plans on calling any witnesses. People have 1 witness. I would ask for mutual sequestration just in case.
I have no witnesses.
Witnesses are hereby ordered sequestered.
And then finally, there was an offer that was extended to waive up and plead to count 2 under HIDA. My understanding is the defendant does not wish to avail himself of this offer at this time and wants to hold his exam.
Wishes to hold his exam. He's eligible for HIDA with judicial consent. So I'm not, basically what I'm saying, we're not necessarily rejecting that, but he is asking to hold his exam. It's my understanding if it's found over, he can still ask the judge for HIDA because he's HIDA eligible.
But there would not be an agreement for the people to
that.
Correct.
All right. All right. Proceed.
We'll call Deputy Bryant.
Testimony about give proof the whole truth, not the truth. They story first and last name for the record. First name is Kai K-A-I. Last name Bryant. You got wife kids.
All right, thank you. You may proceed.
Thank you. Good afternoon. How are you doing? Doing just fine. Thank you for asking. Sir, how are you employed? How are you employed? And in what capacity do you work for the sheriff? How long have you been working as a deputy? So, any previous law enforcement experience? Where did you work before? How much law enforcement experience do you have? I want to turn your attention to June 9th of this year. Were you working for the sheriff on that day? At any point that day, were you dispatched to 1241 Stamford Court in Superior Township? What were you dispatched for? At any point that day, did you have contact with an individual by the name of Lance Ford? Do you see that individual in the courtroom today? Can you please point to them and identify them by an article of clothing that they're wearing? The record may reflect this witness has identified the defendant.
That objection record shall so reflect.
Okay.
Where did you first have contact with the defendant on that day?
Inside.
And this unit, is this a house, an apartment? What sort of unit is it?
So, fine.
All right. How would you describe your initial interaction with the defendant?
I've never seen him. He was shaking. Quite even nervous of our president.
What was the course or purpose of your investigation?
I already found to figure out the situation. About just the words.
And without getting too much into the details on that, what did you end up deciding to do between the parties?
Decided it's best for both parties.
And when you say both parties, who is that? What did you do then with the defendant?
We offered him a ride.
To where?
House down the road.
Why'd you offer him a ride?
That was not that. Yes. Felt like walking.
Where was that conversation about having a ride? Where did that conversation take place? At that time or at any point, was the defendant ever detained?
Before that, it was that.
At that point, what, sorry?
Wasn't asking for the ride before that, he wasn't.
How many officers were, or how many deputies were present when you offered the defendant a ride?
There were 4 deputies, 2 in the parking lot.
Was the defendant handcuffed at that point? Were you surrounding the defendant? What happened when you offered the defendant a ride?
He accepted it.
Did the defendant verbally accept it, or did he just sort of go with you? What specifically did he say? Do you remember? What did you do at that point?
You see the walk towards the patrol vehicle. One of the deputies asked him to hold the search the bag. Second that.
Why did you feel the need to search the defendant's bag?
Whenever we put a subject in the patrol vehicle search, like for courtesy advance, we'll search the bag.
Just for clarity first, did you order the defendant into your patrol car? Did any deputy or other law enforcement order the defendant into your car? Did the defendant allow you to search his bag? What did you find when you searched the defendant's bag? And for the record, what is that?
Let's see, the small combat pistol. Shared at 357.
Was the weapon loaded? Did you find any ammunition? Where? Where was that magazine? Do you have your body camera active while this was happening? An opportunity for that body or prior to testifying today? If you saw it, do you think you'd be able to recognize it? I'm gonna plug myself in. If I can put up for authentication purposes, what's going to be marked as people's version, it's gonna take me off for some. Deputy, what did you do after you discovered the handgun?
We're Americans that were in the house.
If I can have just 1 second, please, Your Honor.
Yes.
I'll pass the witness at this time.
All right, cross-examination.
Oh, yeah, I can bring it up. Sorry, I didn't know you needed the rights. Where do you want it from? The beginning or the 32?
If you go, is it 32 or 34?
3214 is where.
Yes, 3214 is. I may go a little bit back, but I'll announce it.
I have pulled up where you want to read.
Okay, okay, Deputy Brian, correct? All right. Good afternoon. My name's Attorney Trovia Star. I'm gonna ask you some questions this afternoon, okay? So, is it customary to offer a suspect, potential suspect, or individual a ride in your car or any patrol car? From time, why time to time? Depends on what.
The conditions, it was hot that day.
Okay, so if it was extremely cold, you would give somebody a ride? If I told you one time I was stranded and it was extremely cold and I called the Washington County Sheriff's Office for a ride and they said, no, we don't do that. Would that sound right?
Jack speculation.
That's not speculation.
Are you saying that that's something that happened?
Yes.
Or are you saying, well, then there's going to be a lack of foundation unless, so.
I'm sorry.
Yeah. So yeah, I'm going to sustain the objection, but also there's a lack of foundation if it's something that actually happened.
Do you deny, or in your experience as a deputy with the Washington County Sheriff's Office, have you ever seen the Sheriff's Office deny someone a ride when they call under extreme weather?
Who did that?
The Sheriff's Office, whoever the dispatch, yeah. No idea. Okay. All right. Let's get back to that day. It's your testimony that my client, Mr. Ford, was asked if he wanted a ride and he said yes, correct? Now, you're not allowed to force someone to get in your car, correct? You're not allowed to, if they say no, you got to come with us, correct? Okay.
You'll need to plug cable and plus the right hand side.
I am now going to replay People's Exhibit. Oh, no, yeah, oh, there you go. Okay. I'm going to now replay People's Exhibit number 1, except I am going to go back to 3150.
They want is and they all the problem behind.
Now, isn't it true that you just heard Mr. Ford say, I'm not going to have y'all take it?
So it sounds.
All right, so he didn't say yes to a ride.
It's to that point. Until he was asked by Roberts.
I'm going to resume playing at 3220.
It's not that hard to get to 95, excuse me.
Now, is that you saying we'll take you?
He answered saying yes to W. Roberts, to
And take them in terms of give them a ride, correct? Now, anytime someone gets in your vehicle, I believe you testified that you search their belongings, correct? Okay. One moment. Nothing further. Thank you. Redirect.
I have no redirect, Your Honor. Thank you.
All right, thank you. Sir, you may step down. Thank you. Additional witnesses for the people.
None, Your Honor.
None from the defense, yeah.
All right, do I have a motion?
People move for bind over as to count 2, carrying a concealed weapon. As people at the beginning, we're not moving for bind over on count 1, felonious assault. Done that today. I believe the court heard testimony and saw the video showing that defendant was all defended his bag towards the deputies after he was told that they would need to search it in order to give him that right. During a search of that bag, the deputy was uncovered, handgun concealed within that bag. Defendant certainly that bag on his person. The people have met the elements by. Ask this court to bind over to stand trial.
Kind of, there are 2 issues, but I'm going to focus on the first issue, which there's a clear consent issue here, Your Honor. Reviewing courts must determine on the basis of the totality of circumstances whether it has been freely given or has been coerced. Actual knowledge of the right to refuse consent is not essential for a search to be voluntary, and police therefore are not required to inform a person of his rights as the Fourth Amendment. But consent will not be regarded as voluntary when the officer asserts his official status and claim a right, and the occupant yields because of these factors. Those are cases Amos versus the United States, 25 U.S. 313, 1921. Johnson versus United States 333, United States, U.S. 10, 1948, and lastly, Bumper versus North Carolina 391, U.S. 543, 1968. Your Honor, under the totality of circumstances, it's clear that my client yielded to the officer's directions. He said, I don't want you guys to take it. You guys don't have to take it. That's further conversation. He never said, you never hear him say, okay, you know what, you will take it. Instead, you hear the officer say, okay, we'll take you. Come with us. Come with us. Something along those lines. It's at that point where, again, as cited, the claim of right, the official status as a deputy saying, okay, we'll take you, even though I just said, I don't want you guys to take me. It's at that point where the lack of consent and the coercion is implied, because I just said, no, I don't want to go with you guys. Now you're saying, okay, we'll take it. What's the other option right there? You just said no.
Start walking towards Stevens Drive.
But see, that's the good point. Now, am I still under control of them? Can I leave? If I walk away from them,
No, but what was any indication that he couldn't have?
Because, okay, we'll take it. If I walk away from him, when he just said, okay, I'll take you, when I just said, no, I don't want to go with, there's two opposite spectrums right there. One side saying, no, I'm not going to go. Another side saying, okay, we'll take you. If you walk away, what does that imply? That I'm not following this person's?
And you're saying that the act of him going from the place that they initially were over to the vehicle was involuntary or coerced in some way?
No, not prior to the statement of, hey, I don't want you guys to take it. Prior to that, no issue. Come over, they talk. I believe they were informing him of a warrant, but that wasn't admitted as evidence. They're talking, and then the issue comes up about, as the deputies testified to, about whether or not we're going to drive you to this particular location, or whether or not you're going to walk. It's clear. He says, I don't want you guys to take me. That should have been it. Any person any officer then saying something else such as, okay, come with us. Okay, we'll take you down.
When you're saying, okay, come with us, you're saying that the officer was saying that he had to go or indicating in some way? Because I'd like to see that on that tape where there's some indication that you have to come with us.
It would be this then. If that's the situation, the onus would be on the person, the individual, to then say again, hey, I don't want to go with you guys. You already said it once. We're not disputing that. We're not disputing that he said, I don't want to go with you guys. So it sounds like he would have to say again, he would have to assert it over and over again. I'm not going with you guys. And he
doesn't keep changing the words because he doesn't say I'm not going.
He said, I don't want you guys to take me. He says, I don't.
They offer him a ride.
Right. And he says,
I don't want you to take me.
Right. And then the officer says, okay, we'll take you. So again,
at that point, you're saying that the officers did something to make him believe that he had to go?
Yes.
What was that?
By saying that we'll take you after I just said, I don't want to go. You guys don't have to take me. I mean, this is not me saying this. This is not an attorney saying, hey, after someone says, after I say to a person on the street, hey, do you want to ride? They say no. You say, hey, are you sure? He didn't even say that. He said, okay, we'll take you. And again, we know that from his testimony.
So the purpose of the officers doing that was to do what?
As he stated, to try to search his. That's why I was getting it. We know that it's custom is if a person is inside the police car, that they search their property for safety reasons. This was
would the officers have been within their right, given the circumstances, to search his bag when he comes out with it and he's in the presence of the officers for the officer's safety?
No, not at that point, because the investigation had wrapped up. And now there's a discussion about some type of warrant, and it's over with now.
Yeah, but at some point, and I'd like to know, you're asking me to make a determination based on only certain pieces, right? Because when you say there's a discussion about a warrant, what's that discussion?
It's from the audio, it sounded as though the discussion was, yeah, go take care of it, and that's it.
That he has a warrant.
And then it transformed to, okay, whether or not you want to ride. Again, I'll just say this point clearly. My client said, you guys don't have to take it. It almost sounds like he has to say that again. That, hey, no, after the officer says, we'll take you after he declined, it sounds like he has to say it again. In order for it to be.
Or not go.
Or that's, now if you say, okay, or not go, now it's like, okay, his words are ambiguous. When he says, you guys don't have to take it. If a police officer asks.
I'm not arguing that they forced him into that vehicle.
That's where it's exciting in the case. We're talking about an appearance of an official status, right? This is a police.
What did the officers do from the time that he's at the side of the one vehicle and heading over to the other vehicle that made him go to that other vehicle?
Did not adhere to my client's statement of
no. But they didn't move his legs, right?
You don't have to force someone to do anything with coercion. You can verbally say, no, that's okay, we're not going to do that. Again, that's what we're talking about.
Sorry. From the point that he's at the side of the vehicle talking to, I think that was Roberts, right? to the point that he goes to the other vehicle, what did the officers do that made him go to the other vehicle?
Statement of, yes, we will take you.
That's what the officers did.
Yes, the statement of, yes, we will take you. When he just said, I don't want you guys to go.
I hear what you're saying in terms of what was said. But all of that is said at the one vehicle. What coerces, because you're saying that the officer somehow coerced him to go from that one vehicle to the other vehicle? What did the officers do? They didn't surround him and kind of force him that way. As I see the tape, there are officers in the area, but they're not surrounding. So what you're saying, it was the officer's statement of "we'll take you" that made your client go from that one vehicle to the other?
After he said, I don't want you guys to take me. That's where we start talking about official status. This person with an official status as a law enforcement officer, after I told him, after I denied his offer, is now saying, okay, we'll still take you. Again, it sounds as though like we're saying that's not enough for the person in that situation to decline the offer. It sounds like we're saying there has to be more. There has to be more, such as, oh, you walk away and then they grab you and say, no, you got to come with us. Or no, you have to come with us. It sounds like there has to be more than just simply declining the offer. Under normal circumstances, when the police are talking to anyone, when they're interrogating anyone, the moment someone declines, that's supposed to be it. It's supposed to stop right there. There's not supposed to be anything after that.
So the officers shouldn't engage citizens after that? I guess I'm still not understanding the point. What?
If you decline, yes, that's where we're talking about the official status comes into play. Because if you're declining an officer's request and then they still say, hey, come with us, we'll take.
But hold on, they're not saying come with us, we'll take you.
Yes.
To which he can say what?
So you say what? Say it again. He would have to say it again.
No,
I don't want to go.
No, I got it. That's all right. And just start walking off.
Again, I'm not disputing that, but that's my point. It sounds like there's more. He has to do it again, which under normal circumstances, that's not the case. That's what we're doing.
You've never been in a situation where somebody offers you something, you say no, and then they say something to you, and then you change your mind.
That was my example in terms of me as an attorney offering someone as a ride. And I say, are you sure? Are you sure? Here, the problem is we're talking about a law enforcement official, and that's what we're talking about as the case.
So all of this, by your argument, was sort of a pretext for those officers to search the bag.
Yes. He said anytime someone.
But hold it. They really wanted to search the bag, and be careful on your answer. They can search that bag based upon the fact they know he's got a warrant.
They're cutting him loose, though.
No. But they could, if they wanted to, listen to what I'm saying. If they wanted to search the bag, that was this deputy's sole intent in life at that moment, that they want to get into that bag. They have the ability to do it.
And they didn't.
Before that point.
They didn't. Because
that wasn't their intent to get in that bag. Your argument fails on itself, Mr. Starr, because if they wanted in the bag, then there's no question whatsoever of anything. What you're then saying is all of a sudden they're at that point and now they're going to create some ruse to try to give him a ride for the sole purpose of searching the bag when they could have done it 5 minutes ago or whenever.
One point about the warrant. More important about the warrant. It all depends on when they discover whether or not they're going to arrest him for the warrant. If they're going to arrest him for the warrant, yeah, absolutely, they can search that bag all day long. But if it's a cut and release, like it appeared to be, they're not going to search the bag.
The deputy testified that at some point your client's detained by them. If they wanted in the bag, they could get in the bag at the point of detention. That's where your argument makes no sense. That then after that point, they have to create some ruse to get into the bag. I don't think your interpretation, maybe others that disagree, your interpretation of that conversation that took place between that individual and the officer led to some type of coercion or lack of consent. Those officers did not move your client's feet from that one vehicle to the next vehicle. I didn't see the officer saying or grabbing that bag out of your client's hand. I didn't see them put him in cuffs till after they discovered the weapon. None of that. Is there anything else?
That's like I said, it has to be more. I understand the court.
Like your argument should be more. Anything else regarding your argument? Anything else regarding your argument?
I respect my argument. That's all I'm saying.
Anything from the people?
No, Your Honor.
Court has listened to the testimony in case the defendant is charged with the carrying of concealed weapon. It wasn't even necessarily of an issue of consent, but to the extent one has to do, there was nothing that the court sees in the video or anything along those lines where these officers were taking away this individual's ability to consent, or that in some way and or another coerced him either to go to the vehicle to accept their ride or to coerce him into the search of the bag. I would further state that, and just to repeat this as part of my decision, the argument of defense in this court's mind is illogical. If the officers or deputies wish to get into that bag, there are points at which they could have certainly done that and legally done that. They could have done it at the point of detention. They could have done it the point of potentially an arrest on the warrant. They don't arrest him on the warrant. They offer him a ride. He initially may decline that ride. They indicate that they'll take him over to Stevens Drive. He goes with them over to the vehicle and does that. I don't think you can sit there in this court's mind and sort of blame the officers that what they're doing is that they're somehow flashing their authority to force him to do anything from that point. Defense admits that he is released at that point. He didn't have to do anything. He could start walking towards Stevens. So given, I think that argument fails, it is clear from the testimony in this case that the defendant was carrying a weapon concealed within the bag or the knapsack, whatever one wants to call it. The people have sustained their burden. The defendant will be bound over to stand trial on carrying a concealed weapon. Count one is dismissed. As to the information, Mr. Stark.
We stand mute with.
But in every way, form, reading, standing mute, the court will enter a not guilty plea as to count two. Pretrial in this matter will be set
September 17th at 1:30 with Judge Slay.
September 17th, 2026, 1:30 for Judge Slay. Bond will continue. Thank you.
Information prepared and filed with the court.
Thank you.
Have a good day, Your Honor.
Take care. We'll be ready on the next one momentarily. Where'd Saxon go? Ms. Saxon?
What begins as a routine criminal docket quickly turns into a courtroom full of unexpected twists. From defendants asking to fire their own attorneys to bond requests being denied, the judge makes one thing perfectly clear. every decision must be based on facts, not emotions. One of the first memorable moments comes when Justin Heaton tells the court he wants to remove his lawyer and represent himself. Instead of rushing into such a serious decision, the judge slows everything down. He explains that experienced attorneys are there for a reason and postpones the case so more information can be gathered before deciding whether the defendant can safely handle the case outside of jail. Rather than making a snap ruling, the judge focuses on getting the full picture first. Later, another defendant asks to be released on a personal bond after several charges are reduced. His attorney argues that he's already on tether in another case and promises he'll stay away from the alleged victim. But the judge immediately notices something important. The new case involves the same alleged victim as another domestic violence matter. That changes everything. Without hesitation, the judge denies the request, explaining that public safety comes before convenience. The courtroom takes another turn when Gregory Huff enters a no-contest plea to a domestic violence charge. Before accepting it, the judge carefully explains every constitutional right the defendant is giving up, making sure he understands the consequences. When the paperwork isn't complete, the judge actually stops the plea proceeding until the advice of rights form is properly signed. Only after confirming everything is voluntary does the court accept the plea and schedule sentencing. It's a reminder that even when someone wants to plead, the process must be done correctly. But perhaps the most dramatic exchange comes when Christian Reed faces allegations that he failed to stay in contact with community corrections. His attorney argues that a broken phone prevented him from proving he made the required calls. The judge listens patiently, but refuses to rely on promises alone. Instead, he demands one thing: proof. He tells the defense to produce phone records showing the calls actually happened. Until that evidence is provided, the defendant will remain in custody. The judge's message couldn't be clearer. In court, evidence always outweighs excuses. By the end of the hearing, one lesson stands out above everything else. Whether it's asking for bond, entering a plea, or claiming you followed court orders, every request must be backed by credible facts. The judge shows compassion when appropriate, but never at the expense of accountability. What do you think?